The American courts as well traced this right to privacy to the English common law, but initially they also associated with only the right to property. But as things progressed, I think there have been a number of decisions. I would not like to take you through all these decisions, but I think slowly but steadily, over a period of a century or so, the Supreme Court of the US also gradually moved from the protection of privacy as a mere right to property associated with right to property to what we call it as right to person. Right? I think that is one important development we have to keep in mind, for which this first written constitution of the modern world did not have a specific right on what we call it as privacy right. The courts were by and large interpreting the Fourth Amendment to the Constitution, and they started interpreting the Fourth Amendment as if it also contained the right to privacy. And if one analyzes the judicial trend in the US during that century between 1900 till the fag end of 2000, one can easily see that they were not saying that right to privacy is an isolated right. It is a concomitant right of all other rights. So you have to draw from each and every right for you to protect your right to privacy. And that is how the American Supreme Court had very clearly moved forward. But yet, it consistently held that right to privacy is not an absolute right, because it is evolved from various other rights. They always said that it is not an absolute right, and that it must be based on, that limitation must be based on a probable cause as stated in the Fourth Amendment. So that is very clearly indicated that a right that is being evolved by the judicial interpretation, the courts were also careful in saying that this right is not an absolute right. And for that matter, no right is absolute, because every right can be regulated and at times even prohibited. If one looks at the Fourth Amendment developments, the courts have identified different techniques. The intrusion into the right to privacy, which the court permitted, must be based on only three different ways or methods. The first one is that there must be a law, a legislative law, so that under that law, some sort of intrusion is permitted into the right to privacy of an individual concerned. The second one is, if the law is silent, it may authorize the administrative authorities, who may pass series of executive orders, which are also scrutinized by the courts from time to time, and they are also permitted to intrude into the right to privacy. And finally, the judiciary itself can authorize for what you call it as balancing of this right to privacy with the other interests that are provided under the Fourth Amendment to the American Constitution. But all these intrusions, whether it is legislative, whether it is administrative or judicial, must be tested against, once again, three important factors. One is the reasonableness guaranteed under the Constitution. Even if a law is made which provides that authority the power to intrude, it will be tested against the concept of reasonableness. The second test that the courts have evolved is the proportionality of invasion. Whether this is the right proportion in this particular case. Maybe in another case that may not be the same. It may be lesser, it may be higher in some other case, but the proportionality of the invasion will also be looked at by the court. And finally, what is the purpose that you are going to achieve when you intrude into the right to privacy of an individual concerned? And these developments of given by the judiciary over a period of time have provided what you call it as the flexibility necessary for the continued development to identify, because it's too extreme, right to privacy on one side and the national security on the other, to strike a balance, a note of balance between these two extremes. I think that flexibility was provided by the courts in their approach. Let me just look at the international developments. I will not get into the details of this, but I thought it is my duty to inform the audience today about the importance and relevance of some of these instruments. This year, particularly, we are going to celebrate the 60th anniversary of the UDHR. As students of law, we all know that UDHR is only a declaration. It's a non-binding declaration. There is no party which has ratified or become a party to implement it. But over a period of time, the UDHR has become the customary principle of international law. I think the two covenants are also squarely based upon the provisions of UDHR because it's a non-binding agreement. So they wanted to put it as binding agreements, and that is how the two other covenants developed subsequently in the year 66. Article 12 of the UDHR very clearly provides no one shall be subjected to arbitrary interference with his privacy, family, home or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of law against such interference or attacks. Now this was adopted by the General Assembly. I think India was also a member of that General Assembly, and we have not done anything. 1948, the declaration is there, right? And we have come back and we have not translated this into any sort of what you call it as a concrete piece of legislation. Similarly, as I mentioned to you, as it is a non-binding declaration, they also divided that into two parts. The first and the second covenant on civil and political rights, economic, social and cultural rights. Article 17 of the first covenant on ICCPR, to which India is a party, provides the same that I mentioned to you on tune with Article 12. They reproduce the same as it is by and large, and Article 17, and if it is binding on India, and India had ratified it in 1978, and from 1978 it is almost 30 years, and are we able to provide a legal framework, a proper legal framework to protect the rights that are mentioned in Article 12 of the UDHR or Article 17 of ICCPR. For favor of balancing this right to information, I need to mention to you the European Convention on Human Rights. When you are talking about privacy rights, I don't know why all of a sudden I am mentioning about human rights, because this convention is filed on European Convention on Human Rights, which came into force in 1953. It's almost 55 years old now. Along with the protection of the right to privacy, this convention also provides under Article 8 for certain limitations. I think it is also, we are looking not only right to privacy but also the possible limitations. It says the limitations according to Section 8, Article 8, a public authority may interfere, because it gives a series of grounds on which the right to privacy can be intruded or violated. It said the public authority may interfere with the right to privacy on the basis of a law. That is the first one. So there must be a law in the proper sense, a law to be enacted by the legislature, not a law to be made by the executive by its orders. And in the interest, and that law must be based on the interest of national security, public safety, economic well-being of the country. See, 55 years ago, this convention was able to throw light. Human rights is fine. Right to privacy is also fine. But they must also be conditioned by series of limitations. And I am just reading out those grounds. A law is mandatory, and that law must be based on the national security. The second one, public safety. The third one, economic well-being of the country. The fourth one, the protection of health of the people. Morals, or for the protection of the rights and freedoms of others. I think that is a place where we have to learn something. It is not the right to privacy that my right is to be protected. But when I protect my right, it should not injure the right of another individual. I think is what we have to learn from Article 8 of the European Convention. The objective of stating this brief history very quickly is to indicate clearly that irrespective of the developments that are taking place in the world, the framers of the Indian Constitution did not include the right to privacy as a right under Part 3 of the Constitution, because they had the benefit of the UDHR, they had the benefit of what was happening in UK, they had the benefit of all the interpretations of the Fourth Amendment to the American Constitution. For what reasons I do not know, because it's very easy for us to find fault with them now. But whatever rights they have given, they did not specifically provide for this right to privacy. Right? I just leave it to you to analyze why they did not include this right to privacy as a fundamental right. Yet, Article 51C, read with Article 253 of the Indian Constitution, as well as the plethora of judicial decisions that we have before us, have recognized what you call it as the right to privacy under various articles in Part 3 of the Constitutions, sometimes under Article 19(1)(a), sometimes under Article 19(1)(d), sometimes under Article 19(1)(f), and also under Article 21. While the first three mentioned goes only to the citizens, Article 21 rights should also go to any person, irrespective of the fact that he is a foreigner or not, or she is a foreigner or otherwise. If you bring all of them under Article 19 as right to privacy, as the courts have said, I think it should also be subjected to the limitations specified under the appropriate provisions in 1902 to 1906. So when you look at a very quick survey of 1902 to 1906, you will find whatever the European Convention on Human Rights had said, some of them get, not all of them, some of them get reflected in these grounds of restriction provided under Article 1902 to 1906. For example, the security of the state, public order, the interest of the general public. On these grounds, it is possible for us to regulate, restrict, and at times even prohibit the right to privacy. I think this is the lesson for which we have to look at, and I think there is once again a plethora of judicial decision where the courts have said if there is nothing contrary to the international convention to which India is a party, still we can incorporate those conventions as they are and direct the administrative authorities, the implementing agencies, to give effect to them, though the law is missing by and large. I would like to very quickly, if time permits, quickly rush through some of the judicial decisions. Possibly the first judicial decision which took us to right to privacy in one form was MP Sharma versus Satish Chandra in 1954. I will not get into the details of that. But the subsequent two cases which substantiated the right to privacy, Karak Singh versus State of UP in 1963, and further substantiated in Govind versus State of Madhya Pradesh, where Justice Matthew had taken us for a very quick survey of what this right to privacy is, where he has compared all the developments that have taken place in and around the world, and I think that is a place to ensure the conditions favorable to the happiness of the people. There are other cases like Rajagopal versus State of Tamil Nadu, which found the right to privacy as part of Article 21 and also defined right to be let alone. Right to privacy is right to be left alone or let alone. In PUCL versus Union of India 1997, which is popularly called as telephone tapping case, the Supreme Court even went to the extent of laying down 9 guidelines. Now this is the purpose that we have to keep in mind. On one side they are saying that they are evolving the right to privacy, and when the right to privacy is being violated left, right and the center, the court started limiting the powers of these administrative authorities by evolving these guidelines way back in 1997. Again PUCL in another case which is very important case, particularly those who would like to speak on terrorism, in 2004, I think the Supreme Court went to the extent of saying that the lawyer has no privilege, cannot claim privileged communication. If the lawyer gets the information from an accused, right, who is said to be stamped as a terrorist, but he is still an accused, and if he gives the information that today the Bangalore airport is likely to be attacked, tomorrow some other railway station is likely to be attacked, after 1 week some other target is there. So they have all this information available, and that information is given to the lawyer. The lawyer cannot claim any sort of privileged communication between the client, and because the larger interest of the society is what is important, not the right to privacy of the person who is accused. Yes, of course, he should not be subjected to torture, so on and so forth. We respect all those things. But I think what the court was saying is that even a lawyer cannot claim privileged communication because the security of state is more important in this matter, because it is a case-by-case analysis. In this case, the security of the state is more important. And I need not tell you about the decision of the Supreme Court in Mr. X versus Hospital Z on the right to privacy of private individuals. It is not between the general public and the state, but between two private individuals. And I will not get into the details of that. And where the Supreme Court said right to privacy is not an absolute right once again. There is Shraddha versus Dharampal in 2003. And I would like to just finally quote Justice Bhagwati from Maneka Gandhi, 1978 Supreme Court, where he evolved the triple test to limit or violate the rights provided under Article 21 of the Constitution. That is, the first one, it must prescribe a procedure. It must prescribe a procedure. The second one, the procedure must withstand the test of one or more of the fundamental rights conferred under Article 19 that may be applicable in a given situation. So they did not say which one. Whatever is applicable, that restriction must be satisfied. Or what we can call it as case-by-case approach. And finally, must be liable to be tested with reference to Article 14, that is, just, fair or reasonable. So which means, on one hand, the courts did evolve the right to privacy in India, in spite of the fact that this right was not specifically provided for in the Constitution even today. They have evolved, but at the same time they also understood the importance and relevance, and they started limiting it, right? So that it is the right to privacy not versus the interest of the state, but it is the overall objective of the civil society in which we are living in. This right to privacy is now being questioned, challenged, and that's the place where I thought I would speak a little on the right to privacy versus the security of the state. There are implications for right to privacy under ICT. For a country, the most powerful country in the world, which claims to be the most powerful country even today, it was a shame, a sense of shame, which they had to take when the Twin Towers were brought down by the acts of, I don't want to call it as terrorism or whatever, but the fact remains the 9/11 incident woke them up. And then the amount of work that they have done, the amount of literature that is available, the amount of conditioning being tested in the courts, being tested before the general public, so on and so forth, I think we can do even hundreds and thousands of PhDs on this literature that's available. Why I'm saying this is, they are now looking at the security of the state on what you call it as high alert status. Now think of the situation, and that is why in one of the conferences somebody pointed out, the moment a terrorist is being tried, there are umpteen number of NGOs, the lawyers coming forward to protect them. But there is not a single soul to speak about the victims of that particular terror act, where maybe few people are killed and hundreds of them are maimed, right? There is no one to talk about them. I think somewhere the reality, I'm not here to preach that we should always condemn these criminals, certainly not. But I think we have to look at the act of balancing between the two extremes, the right to privacy on one side and the sovereignty or the security of the state on the other. Because once the state comes to an end, there is nothing that we can speak about. We will not be sitting together like this, and because we will be going back to what Thomas Hobbes has said, the homo homini lupus situation, where a man will be a wolf to his fellow being. I think if we have to remain as a civil society, we have to sacrifice certain rights. And that is the reason the most advanced country like US, which fought for right to privacy, today the individuals are willing to sacrifice that right to privacy for what you call it as the protection, the overall protection. I think there is a lesson that we have to learn from them. It is not that always we speak about privacy but we do not do our obligations. They are willing to. And that's the reason the whole lot of development that is taking place from the US we have to keep in mind. The second example I would like to give is Canada, which is the most peaceful country. But immediately after this September 11 incident, they built the third terminal in Toronto. They had two terminals, so they built the third terminal. And there was a 16-page release in the newspapers on the facilities available in the third terminal. And the title was Eye in the Sky. Anybody entering into the airport from that point till they board the plane or till they leave that airport, in one building, one terminal, they have installed 10,000 cameras. I don't know whether they are in the toilets, I don't know. But 10,000 cameras to view, to analyze. Sometimes, it is an agony. They also installed some cameras in some of the shopping malls in Delhi. But the recent blast, they found out that the cameras were not working. Right? Where is it that, where can you put an end to all these things is a question that I would like to raise. I have no answer to give. But it is striking a balance. The conclusion that I would like to draw is striking a balance. I may strike a balance which you may not agree. You may strike a balance which I may not agree. The police may strike a balance which the general public will not agree. The IT people may agree on something which the general public or the state may not. So, we have complications all around us. And we have to come together, put our heads together, and have a clear consensus to move forward. The violations that are taking place in the technology is also good. It serves both good and bad. Let me just tell you, privacy is good, no doubt about it. Once again, when I was in Toronto in 2002, this happened. This is a small NGO headquartered in Toronto, which was working for the rights of the child, protection of the rights of the child. There were about 17 employees in that office. There were offices all over the country and other countries as well. But there were 17 employees in the Toronto office. And one fine morning, the executives of these NGOs came to that office and terminated the services of 15 people on the spot. No questions asked. Terminated the service. Why? After they left the office, because they got the feedback that these 17 people have been exchanging pornographic material, and particularly child pornographic material, and they are all protecting the rights of the children. On the contrary, they have been receiving, sharing and sending pornographic material across to each other, and all of them got embedded in their hard disk. Silently they removed all of them, and they immediately removed 15 of them. 2 of them, because they were able to see that though they received, they deleted it immediately without even opening them. So is it possible all these things? I do not know, but the fact remains, science and technology has improved to such an extent, it is possible to identify each and every behavior. And in this case, it has served a good cause. Right? It's not, we are talking about privacy, but those who are supposed to protect the rights of the children, if they become the villains of the protection, then I don't think right to privacy will be even questioned. The violation of the right to privacy will even be questioned. The next one I would like to mention is about the inability of the enforcement agencies. Dr. Suresh Babu is here, who has been in the police service for quite some time. When we are talking about science and technology, the criminals are always much advanced in the state. When the police force is still working with 303 to demonstrate the Second World War peace, they are all walking across with AK-47 or much more advanced, I don't know what they are. Similarly, in information technology, those people who violate the right to privacy are well advanced, technically much more qualified than many of the people working on various industries. The inability of the enforcement agencies to track them, to penalize them, there are a number of other issues. For example, can we think in terms of giving universal jurisdiction? I think you must have seen the US going and tracking somebody in Thailand for having hacked the website of one of the websites belonging to the government of US. So they tracked him down to Thailand, but the question is, how are you going to enforce it? If it is Thailand, it is fine. Now think of a situation if the person was in North Korea. Nothing would happen. So these are all issues which we have to look at it, and to that extent understand